Hello everyone, this is Sudhir Kumar Dwivedi, Assistant Professor of Law. The topic for today's lecture is related with the fundamental rules of pleading under the subject drafting, pleading and conveyancing. So first of all, let's try to understand what is the pleading. So pleading can be defined as a formal statement that requests the court to either grant a relief or pass a verdict in dispute. So whatever has been stated with a point of view that the court will grant some relief or pass some verdict on certain statement which has been pleaded before the court, and such statement may be pleaded by the plaintiff and maybe by the defendant, and after considering the fact which has been pleaded before the court, if the court may give some relief or verdict in dispute, in nutshell it can be said that the pleading is a form of expression of the views of the cause of action of the defense to the court with a view that the court will grant a relief or pass a verdict in the dispute in which the pleading has been made. And the purpose of the pleading can be summarized like it will give a notice for a lawsuit to the opposite party that a lawsuit has been filed against the party, means the defendant, and it will help to the court to find out the what is the issue. Suppose the one plaint has been filed, and against that plaint, in reply to that plaint, a written statement has been filed, then it will be easy for the court to find out what is the real fact issue, and it also helps the court to decide the classification of the case, whether it is a matrimonial case, whether it is a case for damage or whether it is a case for recovery, what is the nature of the case. The pleading also helps in deciding the classification of the nature of the case, and accordingly the case will be heard by the judges. Now let's see what are the fundamental rules of the pleading. The very basic fundamental rules of the pleading are four. Number one, that facts are to be stated in pleading and not law. Number two, that the fact and material fact must be clearly stated. Number three, it is the fact on which the pleading party relies on that must be stated and not the evidence which should be proved, means only the fact should be stated, not the evidence. And the last one is that each of the fact must be stated with accuracy and certainty. Let's first see the first one, that the fact and not the law should be stated. Not only the provisions of the law, rather the conclusions of the law are both should, means the provision of the law and conclusion of law both should not be pleaded in pleading. Only facts should be pleaded. The very first fundamental rule of the pleading is that neither the provision of law nor the conclusion of mixed law and facts should be alleged in the pleading. The pleading should be confined to facts only, and it is for the judge to draw the inference from those facts as are permissible under the law, of which he is bound to take judicial notice. For example, suppose in a case it will not be sufficient that Mr. Abu Muhammad made a gift of his property. Suppose one statement is that Mr. Abu Muhammad made a gift of his property to the plaintiff, and the plaintiff should allege here that gift was made, how it was accepted, and how the possession was delivered, because these are the facts which constitute a valid gift under the Mohammedan law. The allege that that Abu Muhammad made a gift will be a conclusion of law from the facts which are not to be stated directly in the pleading. Suppose secondly, we can take the example in a suit for damage for negligence. It is not enough for the plaintiff to state that the defendant has been guilty of negligence without showing how and in what respect he was negligent and how he became bound to use due care to prevent an injury to other. And third one, we can take the example of third example is that when the defendant has to reply to the claim of the plaintiff in a money suit, it is not sufficient for him to state that the defendant does not owe to the plaintiff, but he must allege such facts which go to prove that the circumstances that what were the circumstances the defendant does not you can say circumstances that defendant does not owe to the plaintiff. The defendant should state that he never borrowed from the plaintiff or good were never ordered or were never delivered or that they were not equal to the sample. It is not sufficient in a suit upon a contract for the defendant to merely plead the contract is rescinded. The defendant must plead in what manner, by what means he contends that it was rescinded. So, the fundamental rule of pleading is that a pleading shall affirmatively contain only a material fact on which the party relies, and it shall not contain the facts which are only evidence by which such material facts are to be proved. The reason for not mentioning the law in a pleading is that it is the duty of the court to find out and to examine all the plea of laws that may be applicable to the facts of the case. However, the parties can make their submission about the law anytime. For example, the non-mentality of the suit, which is a point of law, can be urged before the court or in the pleading itself that the suit is not maintainable at all. However, there are certain exceptions to this rule where the law can be pleaded or mentioned in the pleading. For example, foreign law. There must be a statement regarding if the foreign law is applicable, then it is not the duty of the court to know all the foreign law. It is not judicially noticeable thing. So the fact regarding the foreign law must be stated. And if there is a mixed question of law and fact, where a question is one of mixed law and fact, it is permissible and proper to plead both the facts and the legal conclusion. And third one is the condition precedent. So the code of civil procedure provides that any condition precedent the performance of which is intended to be contested shall be mentioned. For example, the requirement or the condition precedent of notice under section 80 of the CPC. And the next exception is the custom and usage of trade. So custom and usage of any trade and business shall be pleaded like any other fact if a party wants to rely on them, but a custom repeatedly brought before the court and recognized by them regularly is deemed to have acquired the force of law and need not to be pleaded. For example, an occupancy tenant is entitled by a local custom and usage to cut trees growing upon his holding. Is not necessary for the occupancy tenant to plead this custom, because this custom has been recognized by the code at various times and it has taken as a place as a law. It has taken a place of law. So such custom which are in the notice of the court and which has taken the place of law need not to be pleaded, and if it is not so, then such custom or usage of trade must be pleaded in the pleading. And in last, the facts of negligence, right and liability unlawful or wrongful acts should be specifically pleaded. Every plea of facts should be specifically raised and proved. The next fundamental rule of pleading is that only material facts should be pleaded. So, the question arises, what is the material fact? The fact which is essential to the plaintiff's cause of action or to the defendant's defense, which prove or fail is material fact. Order 6, Rule 2 of the Code of Civil Procedure has been initiated in this regard, that the rule that the material fact should be not technically and that omission is to be observed, and it may increase the difficulty in the court task, because once you omitted the mentioning of the material fact, you may not be allowed to mention the material fact later on. That's why all the material facts should be stated in the pleading. As we know the what it is, again we can understand what is the material fact, as though we have come to know that the material fact is on which the cause of action relies, on which the defendant relies for his defense, is the material fact. It can be understood like that a fact is material for the pleading of a party which he is bound to prove at the trial unless admitted by the other party before he can succeed in his claim or defense. If one is in reasonable doubt about a particular fact as a material fact, it is better for him to plead that fact rather than to omit it, because unless a fact is pleaded, he shall not be allowed to prove it at the hearing of the suit. A plea of fraud, misrepresentation in a suit must be set forth full particulars of fraud and misrepresentation, because these particulars constitute material facts, and unless raised by the plaintiff or defendant in his pleading, he will not be allowed to prove at the trial. Of course, a material fact can be inserted in the pleading by way of amendment, which is the right of the plaintiff and defendant, but when the pleading is amended, one is likely to be settled within the cost of other side. That's why it is important to for the plaintiff as well as defendant that the material facts should be stated or mentioned at the very initial filing of the pleading. They should not wait for the amendment of the pleading. And the next principle of the fundamental principle of the pleading is that facts and not the evidence should be mentioned. As we know, there are two concepts of uh, in this regard, like the factum probanda and factum probentia or factum probens. The factum probanda is the material fact on which a party relies, and factum probentia is the evidence or fact by which the parties are to prove the case. So the third principle is that, which has been again laid down by the Order 6, Rule 2 of the Code of Civil Procedure. It says that every pleading must contain a statement of material facts, but not the evidence by which they are to be proved. The material fact on which a party relies is called factum factum probenda, and that is the fact to be proved, and this should be stated in the pleading. The evidence or facts by which the factum probenda is to be established is the factum probentia, and factum probentia should not be mentioned in the pleading. Factum probentia are not the facts in issue, but they are only the relevant fact which will be proved at the trial in order to establish the fact in issue. For example, in a suit of damage for malicious prosecution, the plaintiff should only allege in the plaint that the defendant was actuated by malice in prosecuting him, he must not allege that he had previously given evidence against the defendant and the defendant had vowed to take revenge. The plaintiff is by all means entitled to render evidence to prove this fact. Secondly, in a policy of life insurance, the condition that the policy shall be void if the holder dies of his own hand. In defense, it is not necessary to state that the assured brought the pistol a few days before his death and made all preparation to kill himself. It is sufficient to state in the defense that the assured died of his own hand. In some cases where the fact in issue and relevant facts are so mixed up that it is very difficult to separate them, and if it is so, the relevant facts must be stated. For example, where the custom is based on village administration paper, which is the basis of the claim and its sole proof. In such cases, the record has to be pleaded. In the Punjab, we can take the example in the Punjab, Riwaje Aam, the custom are contained by the manual of customary law, which records custom are only evidence and it is not necessary to refer to them in the plaint. Now the last principle is that all the fact must be stated with concise and precise form, and the order 6 rule 4 is regarding the same. Now question arises, how the conciseness in pleading can be obtained. It can be obtained by omitting unnecessary fact, by omitting unnecessary details during the narration of the major facts, paying adequate attention to the language of the pleading. And how the preciseness in pleading can be obtained? It can be obtained by writing out the name and place of the person. Use of pronouns like he, she, this, that should be avoided in the plaintiff or in the plaint or in the written statement by the defendant. Things should be addressed with a name and given the same description throughout the case. It is not think that once you mention the name and all thing and in later stage in later paragraph you are mentioning he, she, this and that should not be done in the pleading. And where an act or document is used in the suit, its language should be used. Suppose if you are relying on any document, what language has been used in that document, the same language should be stated in the pleading by putting that thing in the inverted comma. If or but should be avoided as far as possible, and complicated sentence should not be used so that the court itself cannot understand the thing, and the fact description in passive voice should not be used. It is to be kept in mind that the description should not be in the passive voice. Again, the pleading should be made in paragraph and each fact must be contained numbering. There should be no repetition. All useful document must be stated clearly. So this was the mode how the preciseness can be and conciseness can be obtained in the pleading. Let's try to understand in short that the material fact must be stated in summary form and in a strict chronological order. All unnecessary allegation and their details should be omitted in order to attain the brevity. And also in pleading is not a place for fine writing but only a certain of hard facts. It is desirable to go straight to the point and state fact boldly, clearly and concisely to avoid all paraphrasing and all the unnecessary, unwanted sentences and facts. As far as possible, an active voice should be used, as I have already discussed that passive voice should be avoided. The pleading shall be divided into paragraph, numbered, date, and all things must be very clearly mentioned. These are some the things which must be kept in mind while drafting a pleading. So let's see what are the other rules of the pleading. The other rules of the pleading include every pleading should be signed by the party. Every pleading signed should bear the address of the pleader, which shall be called the registered address. Every pleading shall be verified by the parties. In last, we can discuss few case laws in this regard. First one is All India Reporter and R.D. Dattar case, AIR 1961 292, in which it was held that it was ruled by the court that if there is certain defect in person signature or presentation and in verification of the plaint it can be corrected at subsequent stage of the trial. In the same way, in R. Patil versus K.S. Patil, AIR 1997, Supreme Court 363, it was held that all documents which satisfy the two conditions, not that is not working the unjustification to the opposite party and being necessary to the part to provide the answer to the major question of suit should be presented. Means to say, if it is not affecting the opposite party and the amendment is necessary for the deciding the question of dispute, in that case the amendment may be allowed. That's all about the fundamental rules of the pleading. Thank you.